All rise. We will obey. The International Criminal Court is now in session. Ludensa Corpenal International, 8th word. Please be seated. Where was this?
Thank you very much. Court officer, please call the case.
Thank you, Mr. President. Situation in the Republic of Kenya in the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, ICC 01090111. We're in open session, Your Honours.
Thank you. Appearances?
Morning, Mr. President, Your Honours. For the prosecution, appearances are the same as yesterday.
Good morning, Mr. President. For the victims, the appearance remains the same. Thank you.
Good morning, Your Honours. Mr. Sang's team remains the same.
Mr. President, Your Honours, good morning. Mr. Ruto's team remains the same, and as before, Mr. Ruto is here in court.
Thank you. We also note that from Nairobi we can see Mr. Mutai, so I note he's present, but Mr. Debre I do not see, so I take it he's been excused. The Chamber will now render a ruling on Mr. Mutai's application for the postponement of the witnesses' testimony that was scheduled to commence yesterday, the 1st of September 2014. The application was to postpone it for 21 days. The Chamber has taken note of the preliminary assessment provided by the VWU, as well as the submissions of each of the parties and participants, including those made on behalf of the witness. The Chamber notes that all appeared to be in agreement that some period of postponement was necessary in the circumstances prior to the commencement of the testimony, to the extent that the testimony could not fairly commence yesterday as scheduled. The Chamber hereby therefore grants in part the application for postponement of the witness's testimony, but the Chamber directs that the testimony shall commence on Thursday, the 4th of September 2014 at 9:30 a.m. The Hague time, which we understand to be 10:30 a.m. Nairobi time. The purpose of granting this postponement of a further 2 days is in order to enable the VWU complete its familiarization process with the witness, as well as to enable counsel to prepare. In the circumstances at hand, the Chamber considers the familiarization process to be an important aspect in preparing the testimony for the witness, in particular in order to minimize any stress experienced or to be experienced. Further reasons for this decision will follow. However, in light of this ruling, the Chamber will address a number of related matters. First, it is noted that with effect from yesterday, Mr. Mutai has been provisionally included on the list of counsel admitted to practice before this court. He is therefore formally permitted to represent the witness. It is not necessary for other counsel to be appointed to represent this witness for the purposes for which duty counsel is assigned to him. The Chamber notes in this regard that Mr. Mutai is bound by the Code of Professional Conduct, not only of his own native bar, but also the Code of Professional Conduct for counsel appearing before this court, and in particular obliged to uphold and respect the confidentiality of information in accordance with the statutory framework of the court. Consequently, the Chamber now considers it appropriate for Mr. Mutai to be provided with a copy of each of the witnesses' statements. The Chamber therefore directs the VWU, in cooperation with the OTP, if necessary, to provide such material to Mr. Mutai. Secondly, regarding the scope of representation of the witness, the Chamber considers it appropriate to clarify that the scope of Mr. Mutai's permissible representation of witness 604 is limited solely to the discrete question of possible self-incrimination by the witness and to advising the witness in respect of the applicable provisions in that regard. That fact also informed the Chamber's decision regarding the length of preparation time that the Chamber considered appropriate to grant. For this limited purpose, counsel will be permitted to be present while the witness is testifying and may, with the leave of the Chamber, make representations on behalf of the witness in the context of Rule 74, if required, at appropriate junctures. However, it is not the role of the appointed counsel to otherwise direct or of the witness in any other manner. In respect of the issue of self-incrimination, it is noted that it would not appear from the substantive statements of the witness that significant issues of self-incrimination arise. Nonetheless, as noted in the submissions yesterday, such issues may arise in the context of certain subsequent developments in which the witness was involved, including the apparent sworn recantation of the evidence he provided to the prosecution, and potentially certain contacts he may have had with other witnesses. The Chamber notes that where necessary, an assurance pursuant to Rule 74 of the Rules of Procedure on Evidence can be provided to a witness in order to enable that witness to testify truthfully without fear of the consequences of self-incrimination. Such an assurance would, as specified in Rule 74, Sub-Rule 3C, be with regard to maintaining the confidentiality of the witness's testimony and providing an assurance that the testimony would not be used directly or indirectly against the witness in any subsequent prosecution by the court. It is recalled that the court cannot provide any guarantee against protection in domestic jurisdictions. However, in order to give effect to such assurances, measures including the hearing of testimony in camera, the protection of the identity of the witness, and the placing of relevant transcripts under seal can be adopted. It is noted that an assurance under Rule 74 would not ordinarily cover any Article 70 offences. In the case at hand, the Chamber would anticipate that Article 70, Sub 1A, B, and C are the only provisions which might be of potential relevance. Article 70, sub 1A and B relates to offences of providing false testimony, that is, committing perjury before the chamber, or presenting evidence which is known to be false or forged. There is no exemption from those provisions. However, provided that the witness tells the truth before the chamber, he need have no fear of incurring liability under them. Article 70, sub 1C of the statute relates to, amongst other things, corruptly influencing a witness. The chamber notes that the prosecution has indicated and undertaken that any evidence provided by the witness before the chamber, in this case, will not be used by the prosecution against him for purposes of subsequent prosecution, with the exception of offences indicated in Article 70, sub 1A and B, which concern, as indicated earlier, the offence of perjury or providing false evidence before the chamber. It is understood that this undertaking would cover the use of the witness's testimony in relation to any conduct potentially falling under Article 70, sub 1C. At any rate, the chamber rules that information provided by the witness during his testimony before this chamber may not be used in any subsequent prosecution against him, pursuant to Article 70, sub 1C. Moreover, the chamber will maintain control over the scope and manner of questioning of the witness, where it appears to the chamber that any question may implicate the provisions of Article 70, sub 1C. The chamber will carefully consider the necessity and relevance of such questions to the determinations to be made ultimately in the present case. Where appropriate, the chamber will curtail the questioning of the witness to avoid creating unnecessary risk of self-incrimination in areas which the chamber does not consider either strictly relevant or necessary to its assessment of the evidence of the witness or to the central matters for determination in the present case. Although no specific request for Rule 74 assurance has been made, in light of the circumstances and the submissions received, the Chamber considers it appropriate to provide a ruling on the matter at this time. On the understanding outlined above, which may, if appropriate, include the Chamber directing the questioning of the witness in any manner which limits his exposure to the risk of self-incrimination, the Chamber considers it appropriate to provide Rule 74 sub 3C assurances. In reaching this determination, the Chamber is mindful of the factors specified in Rule 74 sub 5. Consequently, the Chamber orders that for any part of the testimony of this witness where issues of self-incrimination arise, the evidence shall be given in camera, that is, in private or closed session. The identity of the witness and the content of such confidential testimony shall not be disclosed or used in any manner, except in any proceedings which may be brought against the witness pursuant to Rule 70 and 71 of the statute. However, as noted above, these provisions or these purposes, for these purposes, the undertaking of the prosecution and the Chamber's ruling are understood to also extend to matters potentially falling within Article 70 sub 1C of the statute. each of the accused, counsel, the parties, participants, and court staff present or otherwise with access to the evidence are hereby specifically cautioned that breach of this order may result in sanctions under Article 71. The relevant confidential transcripts of the evidence of this witness will be placed under seal, and the court would apply appropriate protective measures to any subsequent decisions in order to give effect to this order. It will be primarily the responsibility of the parties to ensure that all questioning which may touch on aspects of the witness's evidence likely to give rise to issues of self-incrimination is conducted in private or closed session. The witness or counsel on the witness's behalf may, in the same manner, also request private or closed session if it is anticipated that an answer to any particular question may give rise to self-incriminatory testimony. Counsel is directed to ensure that the witness is fully informed of and understands this ruling prior to the commencement of his testimony. Finally, restrictions on contact with witnesses before and during their testimony would apply in respect of witness 604, including to counsel for the witness. In particular, consistent with the Unified Protocol on the practices used to prepare and familiarize witnesses for giving testimony, adopted in this case according to the decision on witness preparation. Once the familiarization process has commenced, there should be no contact between the counsel and witness 604. In particular, counsel will be excluded from the process when the witness rereads his statements. That familiarization process will be conducted with the witness solely by the VWU. The Chamber recalls that yesterday it directed the VWU to commence familiarization, and therefore these restrictions apply with immediate effect. The one exception to this prohibition on contact is that the VWU may facilitate counsel meeting with the witness for the purpose of providing advice and explanation relating to Rule 74 matters, as just outlined. As regards contact during the actual testimony, the Chamber is of the view that the restrictions applicable to the parties need not apply to counsel for witness 604, and that some contact should be allowed. The Chamber finds it appropriate to allow contact on the conditions applicable to the legal representative of dual status witnesses. Accordingly, counsel should refrain from holding any substantive discussions with the witness about the topics that are to be dealt with during his evidence or the exhibits which may be produced. Discussion with a witness about this testimony may only occur after the close of the evidence in the case. Moreover, the basic principles for contact with witnesses as set out in the witness preparation protocol shall apply in respect of any contact, whether before or during his testimony with witness 604, including any contact with counsel. These principles prohibit coaching, training or practicing of testimony, as well as any attempt to influence a witness to testify to factual events that the witness did not observe or perceive. This concludes the ruling of this Chamber at this time.
I'm grateful, Mr. President. And could I ask, we haven't had sight of the VWU assessment. I wonder if you could order that that be provided to the defence. I'd be grateful.
Mr. Steinbach, did you receive that?
No, Your Honour. For the record, I haven't received it either.
Right. The Chamber directs that the VWU is to make available the preliminary assessment. I have been reminded that typically this doesn't go directly to the parties, but the chamber may indicate what it is that the VWU had indicated in their preliminary assessment. They indicated that the witness's condition does not prevent him from giving testimony at this time. That was the preliminary assessment. So the VW then need not directly send this information to the parties. I've already done that.
I'm grateful.
Thank you, Your Honour. Your Honour, may I seek the Court's indulgence just to clarify one matter in Your Honour's finding that appears at page 9, line 22, where Your Honour said, discussion with the witness about his testimony, this is referring now to duty counsel, discussion with the witness about his testimony may only occur after the close of the evidence in the case. I presume Your Honour didn't mean the close of all evidence in the case, but the finalization of this witness's evidence. Am I correct?
That is indeed the case, the understanding.
Thank you, Your Honour.
Now, the next item on the agenda would be the submissions of counsel, again, related to the witness. I think now 80 documents that the prosecution wishes to add on the list of materials that they will like to use during the examination of this witness. For that exercise, the witness and counsel in Nairobi are excused. It will not be appropriate for them to be part of the discussion at this stage. So we may then thank Mr. Mutai for having joined us so far. So we'll see him again on Thursday.
Many thanks, Mr. President. We shall be present on Thursday.
Thank you very much. All right, prosecutor and counsel, we will take submissions on that matter. We will begin with you.
Thank you, Your Honour. Your Honour, the prosecution has made fairly complete submissions in its application pursuant to Rule 35(2). That's filing number 1463, confidential, as expanded upon in its reply to the defence response, filing number 1471, which was submitted with the leave of the Chamber. Your Honours, in addition, the prosecution has submitted an addendum to the filing, which is filing 1474, which doesn't deal in any detail with the legal submissions, but rather is confined to the relevance of the additional documents and submissions regarding prejudice or the limited nature of the prejudice to the defence. Perhaps I can just commence by reiterating the reasons for which the prosecution seeks to add these documents, since they appear to have been the source of some conjecture which is not in line with the prosecution's wishes. And I am aware that we are in public session, so I'll have to temper my language, and maybe from time to time that I may have to ask to go into private session. The first purpose for which the prosecution wishes to submit this list of documents, or these additional documents, and to have them added to its list of evidence. Well, perhaps I should just start with the provenance of these documents. With the exception, I think, of 2 screening notes, the remaining documents are all documents which arose or have been produced subsequent to the commencement of the prosecution's case. The majority of the documents have arisen in the context of the OTP's investigations into what it alleges is a concerted and organized scheme of interference with the prosecution witnesses, which scheme we submit has been the root cause of the necessity for the Chamber to summons the 9 witnesses who are presently the subject of summons in Kenya, as well as 2 further witnesses who are outside of Kenya and who the prosecution seeks to invoke compulsive measures to ensure their testimony. Your Honours, this course of events and this unprecedented attack on the integrity of the court, which the prosecution submits as occurred, runs the risk of depriving this court of much of the relevant and necessary evidence which the Chamber will require in order to reach the truth, to discover the truth, and to reach a proper finding in this matter. As a result of this interference, many witnesses have withdrawn cooperation from the prosecution, have refused to testify voluntarily, and we submit have falsely recanted their earlier versions that were given to the prosecution in witness statements. The defense, I'm sure, will hotly dispute that fact. The defense's narrative is that these witnesses, or a number of these witnesses in any event, are witnesses who were induced through promises of financial gain to falsely incriminate the accused. And the reason why they are now recanting is presumably because their conscience has got the better of them, or they fear discovery, or they fear prosecution, or some combination of the above. The prosecution's version, of course, is that their initial statements were true, and their recantations have, in fact, been bribed by promises and indeed payments of substantial sums of money in the form of bribes, coupled with a systematic intimidation of witnesses, witnesses' families, and a general atmosphere of hostility existing in Kenya towards the ICC and towards ICC witnesses. Now, the first purpose for which the prosecution therefore seeks the admission of this evidence on its list of evidence is in order to confront, where necessary, witnesses who now recant earlier statements given to the prosecution. Now, it is not the prosecution's practice to take statements under oath. Indeed, there is at least doubt as to whether the prosecution has the ability to administer the oath, but these are certainly statements that are solemnly given for the purposes of future evidence before court. Where witnesses have disavowed these earlier statements, the circumstances under which they have come to do so is, in the prosecution's submission, undoubtedly a matter which should be of great interest to the Chamber. If it can be demonstrated that these witnesses were interfered with, either through threats, coercion, or inducement by payments, that is indeed, in the prosecution's submission, a factor which will be extremely relevant for the court to determine whether their recent recantations are in fact the truth, or alternatively, whether the recantations are false, which, in my submission, through the normal process of logic and experience, would tend to suggest that their initial versions are more likely to be true. One could observe that it is hardly likely that someone will spend time and energy to locate, track down, approach, and bribe witnesses, as well as the financial commitment involved, where those witnesses are in fact complete liars and will no doubt be exposed as such through the normal legal processes. Far more likely that witnesses who are being bribed because they are a threat, because they have real, cogent, and incriminating evidence. Your Honours, the defence for Mr. Ruto does not dispute the fact that, or does not object to the fact that this evidence may be used to confront witnesses. I understand that the defence for Mr. Sang does do so. But my submission is that in order for the bench to reach an informed decision as to the credibility or otherwise of these witnesses who will come before the court, particularly those who have already recanted, as well as those who, through their withdrawal of prosecution, of cooperation with the prosecution, may well be expected to be at least adverse to the prosecution, if not openly hostile. In order to properly assess their credibility, the Chamber needs to be apprised of the relevant facts which preceded their recantation or their adoption of an adverse position to the prosecution. Now, that's as regards the evidence of a particular witness about him or herself. But many of these witnesses also have relevant evidence about other prosecution witnesses. The fact that they have already been approached or have accepted offers. And the prosecution submits that it is also relevant for the prosecution to be able to lead that evidence, where possible, from one witness in order to use in the assessment of the credibility of another witness. That is, well, certainly it's a well-recognized purpose of cross-examination. And presumably, well, if the Chamber grants the prosecution, in appropriate circumstances, permission to cross-examine witnesses, that would certainly, in my submission, be an appropriate and permissible line of questioning. Thirdly, Your Honours, it is important for the Court, in my submission, to be able to see the broader picture which is emerging in this case. The jurisprudence is replete with rulings and suggestions to chambers that it should not, or that they should not, adopt a piecemeal approach to their assessment of the evidence, but rather each piece of evidence should be seen against the mosaic of the larger evidence of the case. And it is only when the bigger picture becomes visible that often the chamber is in the position to make informed decisions. And in this regard, Your Honours, I submit that the bigger picture will emerge should the chamber permit prosecution to lead the evidence of the nature which it seeks to do. This brings me to the third aspect, and they're all interrelated, and that is that...
But what is the bigger picture?
Your Honours, the bigger picture is that is the fact that it's not just one witness that's been tampered with, or rather, in considering the credibility of one witness and whether or not the court will accept that the reason why that witness has been recanted is because he or she has been interfered with. Similar evidence laid in respect of other witnesses may indeed be mutually reinforcing and mutually corroborative. And in that regard, the evidence will have a cumulative effect which would be lost if one only focuses on one witness at a time. And that is why the pattern is an important factor. Moving on then to the assessment of the probabilities, I've already touched on this, Your Honours, but there is certainly in the prosecution's submission a competing narrative which has evolved during this case as to whether witnesses have been interfered with, and if so, by whom and for what purpose. And my learned friend for Mr. Ruto has argued in his response that these are separate issues, that this deals with matters which happened a long time ago, and has nothing to do with interference today. But in the prosecution submission, these two matters are inextricably linked, again for the reason that it may be logically inferred that one does not waste one's time, effort, and money bribing witnesses who are doomed to be exposed as liars and charlatans before the chamber. There is an additional but important factor which is to be taken into account, and that is provided by the provisions of Rule 68 in this matter. The prosecution has on numerous occasions given notice to the chamber and to the defense that should the remaining witnesses who have been the subject of summons or who are anticipated to be the subject of further compulsory measures fail ultimately to come to the court and to testify, despite all reasonable steps having been taken, or should they come and testify and recant their earlier versions, and should the chamber be satisfied that the actions described above are the result or are materially influenced by improper interference, including bribery, the prosecution will submit that under Rule 68, the prior statements of these witnesses should be admitted into the record. The prosecution submits, therefore, that any evidence or evidence of the nature which it now seeks to add is precisely the sort of evidence which the chamber will require to have before it to assess and to either accept or reject in order to come to the conclusions which it will be required to make under such a looming application. It would be more efficient in the prosecution's submission to allow this evidence to be submitted in the ordinary course of examining these witnesses, rather than to separate it out and require witnesses possibly to be recalled or otherwise having all of this evidence reintroduced at a later stage, when it must at least be foreseen as a reasonable possibility that this will be required in due course.
On that note, so that I get a clear picture of what's on your mind to do with these materials. Now we have 80 documents, 57 in your first papers you filed, and then latterly another 23. Do they all relate to 604, or do they address all the witnesses under subpoena?
Your Honours, they are limited to the first two witnesses, 604 and 495. Due to the imminent testimony of these witnesses, the prosecution has prioritized those two. But as indicated in the application, the prosecution does anticipate similar applications in respect of remaining witnesses. As to the number of documents Your Honour has mentioned, many of these documents are single-page investigators' notes. A substantial number of them are simply photographs of annexes to witness statements that are photographs of cell phones, or photographs, in one case, of a meeting. They are not, in the prosecution's submission, extremely voluminous. The majority of them have been disclosed at least a month ago, in many cases, often much more. There are, of course, the prosecution concedes a number that have been recently disclosed because of the fact that they could not be disclosed earlier for a variety of reasons which are set out in the filing. But those are, in the prosecution submission, a limited and contained number of documents that would not, in my submission, be unduly prejudicial to the defense, in the sense of an unfair procedural prejudice. Obviously, there's always a prejudice when incriminatory evidence is admitted, but that is not the sort of prejudice which we should be concerned with here. Given the importance in my submission of this evidence, and given the limited prejudice the prosecution submits, that the Chamber should, in these circumstances, exercise its discretion to admit the or rather to allow the prosecution to add the documents to its list of evidence. Obviously, when the prosecution is leading the witnesses or cross-examining the witnesses, as the case may be, the court has the discretion to allow the prosecution to use the documents and subsequently to omit them or not. But for present purposes, the prosecution submits it has made out a case that it should be able to have access to these documents to use them if they do become relevant. Your Honours, if I may address one discrete issue raised by the defence for Mr. Sang, and that is an issue of jurisdiction. The argument is made out, as I understand it, that this court should not concern itself with these any allegations of witness interference, because these ought first to be put before the pretrial chamber for the pretrial chamber to decide on, for them to presumably confirm charges, etc. The prosecution does not seek to have this chamber prejudge any future prosecution that may occur, if indeed such prosecution does occur. Any rulings which the chamber may make as to the relevance and admissibility and ultimately the reliability of this evidence would not be, in my submission, binding on the pretrial chamber. They will be free to assess that on the evidence before them or before it. And this should certainly not be a bar for this chamber to refuse to admit or to consider evidence which is, in my submission, relevant to the issues, live issues in this case, in which the chamber will need for a proper determination of this matter. Unless there are any further questions, Your Honours.
There's the obvious one. The Ruto defense vigorously indicated a concern about whether you are heading or setting up a case of consciousness of guilt.
Thank you, Your Honours. I obviously did deal with that in our reply, but the purposes for which the prosecution has requested the admission of the documents on its list of evidence I have set out, they do not include consciousness of guilt. I am alive to the undertaking my predecessor, Ms. Tai, gave almost a year ago. In fact, it was probably over a year ago now. I do submit that circumstances have changed substantially, but that it is not my application at this time to have the evidence admitted for the purpose of consciousness of guilt. I do not presently intend to do so. Should circumstances change where I feel I have to do so, that will be the subject of a separate admission, a separate application, and all of the issues which were raised by my learned friends would have to be determined by the Chamber at that time. But certainly at this time, I do not make that application. Thank you, Your Honours.
Similar at that time, so we can take it in a logical manner. Briefly.
Yeah, Mr. President, thank you very much. I see the time.
All right. Would you, I see you set up your diet to speak, so I take it you do have some submissions to make, is it?
Yes, we do have submissions to make.
All right. We will rise now and come back at 11:30.
All rise. We will wait.